this guy's garage. Like and subscribe.
While I certainly and my colleagues agree that C-26 is an important piece of legislation that's a long time coming and we need to protect our critical infrastructure, I'm going to take this opportunity to move the following motion that's been properly placed before the committee. That in light of the recent federal court ruling, which found that the government's use of the Emergencies Act in February of 2022 to have been illegal, and that the special criminal laws subsequently created by the Liberal Cabinet to have been an unconstitutional breach of Canadians' charter rights, the committee undertake a study pursuant to Standing Order 108-2 of the Department of Justice's role in supporting the government's illegal and unconstitutional decisions concerning the Emergencies Act, together with the consequences which follow the court's decision, provided that A, the committee invite the following to appear for at least 1 hour each. 1, the Honourable David Lametti, the Minister of Justice and Attorney General of Canada at the time. The Honourable Marco Mendocino, the Minister of Public Safety at the time. Number 3, the Honourable Arif Virani, the Minister of Justice and Attorney General of Canada. Number 4, representatives of the Canadian Civil Liberties Association. And number 5, representatives of the Canadian Constitution Foundation. And B, an order due issue for all legal opinions which the government relied upon in determining that 1, the threshold of threats to security of Canada is defined by Section 2 of the Canadian Security Intelligence Service Act, required by Section 16 of the Emergencies Act, had been met. 2, the thresholds required by paragraphs 3A or B of the Emergencies Act concerning a national emergency had been met. 3, the situation could not effectively be dealt with under any other law in Canada, as required by Section 3 of the Emergencies Act. 4, the emergency measures regulations were compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act. And number 5, the Emergency Economic Measures Order was compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice, provided that these documents shall be deposited with the clerk of the committee without redaction and in both official languages within 7 days of the adoption of the order. Now, it's critically important that we understand why it is that we are bringing this motion forward. It is a very, very important to remember that the federal court, rendered a decision last week that was critically important, and it should have been a landmark for this country and for this government. In order for us to have a clear understanding of what the Emergencies Act was about, how it came to be, the decision of this federal court, and all those sort of different nuances, I want to take some time just to do a very paraphrased version, a summary of the federal court, just a couple of pages. So in Ottawa on January 23rd, the Honourable Justice Richard Mosley of the federal court issued decisions. And in summary, 4 groups applied for judicial review of the decision by the Governor and Council to declare a public order emergency under the Emergencies Act. The February 14th, 2022 proclamation declaring a public order emergency, herein referred to as the proclamation, and the enactment of temporary special measures in order to deal with protests in various parts of the country, which included the occupation of the downtown core of Ottawa and blockades of ports of entry, were under review. Now, this was the first time the Act was invoked since it was enacted in 1988. The proclamation, the Emergency Measures Regulations, the Emergency Economic Measures Order, adopted under the Act, had a threefold impact. A, they provided a range of activities relating to protests in designated areas. B, They required third parties to assist police in ending the protests. And C, they authorized financial institutions to disclose information on designated persons and entities to federal officials and to suspend their accounts. Justice Mosley goes on to write that the applicants and parties raised issues which led to the following questions. 1. Was the proclamation unreasonable? With respect to the first question, the court considered the decision under the reasonableness standard of review and concluded the answer was yes, the proclamation was unreasonable and illegal. Those of you who are lawyers will understand ultra vires. The court said that they acted beyond one's legal power and authority. That's the Latin term for what ultra vires means. Means literally it's beyond the scope or excess of power and authority. While the court recognized that the occupation of downtown Ottawa and the blockades of the ports of entry were matters of serious concern, calling for government and police action, the threshold of national emergency required by the Act was not met. Under paragraph 3 of the Act, a national emergency is an urgent and critical situation that exceeds the capacity or authority of provinces to deal with it, and that cannot be effectively dealt with under any other law in Canada. The proclamation applied the temporary special measures in all of Canada's provinces and territories, despite the lack of evidence that it was necessary. Apart from the situation in Ottawa, the police were able to enforce the rule of law by applying the criminal code and other legislation. While the conclusion of the proclamation was illegal, ultra vires, it was sufficient to dispose of the applications. The court addressed the other issues should it be found to have erred in its findings on the first question. Second, the court considered the threshold of threats to the security of Canada. Section 2C of the Canadian Security Intelligence Services Act, or the CSIS Act, defines threats to the security of Canada as activities directed towards or in support of the threat or use of acts of serious violence against persons or property for the purpose of achieving a political, religious, or ideological objective. Section 17 of the Emergencies Act, or under Section 17 of the Emergencies Act, the Governor and Council required reasonable grounds to believe that the standards set out in Section 2 of the CSIS Act had been met. The evidence in the record before the court did not support a finding that the impunged activities required that or reached that threshold. The second question, as put forward by Justice Mosley, was, did the powers created by the regulations and the economic order violate Sections 2B, 2C, 2D, 7 or 8 of the Canadian Charter of Rights and Freedoms? And if so, could they be saved under Section 1 of the Charter? So what do those sections actually say in the actual charter? Section 2 says, everyone has the right following fundamental freedoms: freedom of conscience and religion, freedom of thought, belief, opinion, expression, including freedom of the press and other media of communication. C, freedom of peaceful assembly, and D, freedom of association. 7 talks about life, liberty, and security of the person. Everyone has the right to life, liberty, and to security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. And Section 8 of the Charter deals with search and seizure, and everyone has the right to be secure against unreasonable search and seizure. And Justice Mosley said if they could be saved under Section 1 of the Charter. Section 1 says that the Canadian Charter of Rights and Freedoms guarantees the rights of, and freedoms set out on it, subject only to the reasonable limits prescribed by the law, as can be demonstrably justified in a free and democratic society. Concerning the Charter, the court found that the regulations infringed the guarantee of freedom of expression under Section 2B, as they were overbroad in their applications to persons who wished to protest but were not engaged in activities likely to lead to a breach of the peace. The economic order infringed on Section 8 of the Charter by permitting unreasonable search and seizure of the financial information as designated persons and the freezing of their bank accounts and credit card accounts. The infringements of Section B and Section 8 of the Charter were found to be not minimally impairing and could not therefore be justified under Section 1 of the Charter. The court found that there was no infringement of the rights to freedom of peaceful assembly and of association in paragraphs 2C and 2D of the Charter, and any infringement in Section 7 respecting the liberty interests of the individual was found to be in accordance with the principles of fundamental justice and thus not a breach of the Charter. Now, I think it's important to understand and how things transpired. How come we had a protest, and how did we get to this place in the first place? It has to do with the increasing degrees of overreach and abuse of power by the Liberal government and their trampling of the charter rights of Canadians. In January of 2022, nearly 2 years after the start of the COVID pandemic, Canadians were growing frustrated with government restrictions and mandates. The straw that broke the camel's back was the order that truckers, cross-border truckers especially, and other essential workers would no longer be exempted from vaccine requirements. This was a threat to their livelihoods and a violation of their rights. And for them, enough was enough. They gathered from across Canada and came to Ottawa and other locations to voice their frustrations, but also to be heard by this government. And I think it's important to understand that this government had no interest in listening to them. And I know that firsthand. I personally, vigorously worked behind the scenes to arrange meetings between then Minister Algabra, Minister of Transportation, then Minister of Public Safety, Marco Mendocino, to meet with protest organizer Tamara Litch, with the understanding that such a conversation would result in the protest being dismantled. However, all attempts to make that happen, personally with them, whether even on a phone call, they refused to do that. The government completely refused, and I think, quite honestly, that their unwillingness to dialogue from the very beginning, had they changed their attitude, they would have certainly, this situation would have been certainly a totally different, and it could have been avoided. The Prime Minister also added to this. He seemed to be fine stoking division, calling people names, allowing frustrations to grow and tensions to grow, until a point where he and his cabinet decided to take their overreach and disregard for charter rights to the next level by stepping outside of the law and their lawful authority and invoking the Emergencies Act for the first time in history. And exactly what did that order say? And I think it's important that Canadians are reminded of what the Emergencies Act actually said. And I will quote from the February 14th, 2022 Government of Canada Bulletin. Whereas the Governor and Council believes, on reasonable grounds, that a public order emergency exists and necessitates the taking of special temporary measures for dealing with the emergency. And whereas the Governor and Council has, before declaring a public order emergency, and in accordance with subsection 25(1) of the Emergencies Act, consulted the Lieutenant Governor and Council of each province, the Commissioners of Yukon and the Northwest Territories, acting with consent of their respective Executive Councils, and the Commissioner of Nunavut. Therefore, Her Majesty, the Governor-General and Council, on the recommendation of the Minister of Public Safety and Emergency Preparedness, pursuant to Section 17(1) of the Emergencies Act, directs that a proclamation be issued. A, declaring that a public order emergency exists throughout Canada and necessitates the taking of special temporary measures for dealing with the emergency. B, specifying the emergency as constituting 1, the continuing blockades of both persons and motor vehicles that is occurring at various locations throughout Canada, and the continuing threats to oppose measures to remove the blockades, including by force, which blockades are being carried on in conjunction with activities that are directed toward or in support of the threat or use of acts of serious violence against persons or property, including critical infrastructure, for the purpose of achieving a political or ideological objective within Canada. 2, the adverse effects on the Canadian economy, recovering from the impact of the pandemic known as the coronavirus disease, COVID-19, the threats to its economic security resulting from the impacts of blockades of critical infrastructure, including trade corridors and international border crossings. 3, the adverse effects resulting from the impacts of the blockades on Canada's relationship with its trading partners, including the United States, that are detrimental to the interests of Canada. 4, the breakdown in the distribution chain and availability of essential goods, services, and resources caused by the existing blockades, and the risk that this breakdown will continue as blockades continue and increase in number. And 5, the potential for an increase in the level of unrest and violence that would further threaten the safety and security of Canadians. Item C, specifying that the special temporary measures that may be necessary for dealing with the emergency, as anticipated by the Governor and Council, are 1, measures to regulate or prohibit any public assembly other than a lawful advocacy, protest, or dissent that may reasonably be expected to lead to a breach of the peace, or to travel to or from or within any specified area, to regulate or prohibit the use of specified property, including goods to be used with respect to a blockade, and to designate and secure protected places, including critical infrastructure. 2, measures to authorize or direct any person to render essential services of a type that the person is competent to provide, including services related to the removal, towing, and storage of any vehicle, equipment, structure, or any other object that is part of a blockade anywhere in Canada, to relieve the impacts of the blockades on Canada's public and economic safety, including measures to identify those essential services and the persons competent to render them, and to provide reasonable compensation in respect of services so rendered. 3, measures to authorize or direct any person to render essential services to relieve the impacts of the blockade, including measures to regulate or prohibit the use of property to fund or support the blockade, or require any crowdfunding platform and payment processor to report certain transactions to the Financial Transactions and Reports Analysis Centre of Canada, and to require any financial service provider to determine whether they have in their possession or control property that belongs to a person who participates in the blockade. 4, measures to authorize the RCM, the Royal Canadian Mounted Police, to enforce municipal and provincial laws by means of incorporation by reference. 5, the imposition of fines or imprisonment for contravention of any order or regulation made under Section 19 of the Emergencies Act. Chair, if I may, the commentary over there, if he wishes to participate in this debate, I invite him to do so after I'm done. Thank you.
Point of order, Mr. Speaker. Mr. Chair. This is just another example of the Conservatives pretending to care about security, as we have witnesses here to talk about cybersecurity, for which the Conservatives pretend to care about and clearly don't.
You can grandstand all you want somewhere else.
Grandstand all you want, really.
Yeah.
The person who's grandstanding?
Can we just stop for a moment, please? Listen.
The person who's grandstanding was working with Tamara Lynch? Wow.
Yes.
This
Biddle?
is
Mr.
unbelievable. Unbelievable.
Biddle,
While you're making
please.
witnesses.
Unbelievable right now.
Who's the grandstander?
Mr. Biddle.
It's clearly you.
Right now.
Oh, yeah, me right now.
Please, everyone.
And I'm quoting here, you know the confines of the CSIS Act, the same words based on legal interpretation, jurisprudence, federal court rulings, and so on. There was a very clear understanding of what those words meant in the confines of the CSIS Act. And what I was reassured by is that there was, in the context of the Emergencies Act, there was to be a separate interpretation based on the confines of that act. Now, under cross-examination by counsel of the Canadian Civil Liberties Association, Mr. Vigneault acknowledged that this was the result of a legal opinion he sought from the Department of Justice. Now, this novel interpretation of a broader definition became a theme in the evidence given by ministers and senior officials before the Commission. It was only when Lametti and Freeland and Mendocino and Trudeau and other government officials
Point of order, please.
testified at the Rilot Commission.
I'd ask the member to recognize these individuals by their proper titles. As Standing Order 18.
Mr. Motz, can you please?
Sure. Minister Lametti, Minister Freeland, Minister Mendocino, and the Prime Minister Trudeau, and other officials, they testified at the Rilot Commission in the fall of 22. That's the first that we heard that everybody was relying on this broader interpretation, this interesting term, on the threshold in the Emergencies Act being tied exclusively and exhaustively to the definition of the CSIS Act. Ms. Thomas answered, the federal government legal opinion is different. For her part, Janice Charette, the clerk of the Privy Council and secretary to the Cabinet, who appeared
Rappel au règlement, Monsieur le Président.
Point of order. I have been listening to Mr. Motz, and it appears to me that the topic that he is discussing today could be referred to another committee on the declaration of situations of crisis.
I respect my colleague and that I will tell her that the Special Joint Committee of Declaration of Emergency will be meeting, and I'm sure we'll be discussing this further. This committee also has a responsibility to
That's very important, what Mr. Motz has just said. The committee is meeting next week?
No.
That's my understanding. And if that's the case, then it would seem to me a bit premature to have consideration of this motion as well as...
The joint chairs are meeting next week. There is no full meeting of the Special Joint Committee next week. And it's important to realize that while the focus of the Special Joint Committee is different than this committee deals with national security and emergency preparedness. I don't see a more fitting committee than this one. Thank you, sir.
Point of order. Sometime having passed, I would like to renew my objection to this motion on the basis that I don't believe the committee has the power to deal with it.
Worth emphasizing that this challenge succeeded thanks in part to good lawyering from career civil liberties defenders who went to fancy law schools and cannot be dismissed, as this government glibly dismisses far too many of its critics as tools of Donald Trump.
Put a finger where you're reading from.
Pardon me?
Put a finger where you're reading from to get back to it.
Thank you.
Mr. Chair, I just think it's important to point out that while Mr. Motz reads from newspaper articles, we actually have witnesses waiting to appear on the issue of cybersecurity who have taken the time out of their busy day to actually come and provide their expertise while Mr. Motz proves his reading skills and simply reads newspapers.
Thank you, Ms. O'Connell.
I would also request that even though Mr. Motz is reading from articles, that he should give due recognition of the titles of the people.
I'm reading what the authors wrote, so I'm not going to change what they wrote.
Well, I think you could interject some respect there. Thank you.
So unfortunately, that's what happens when you interject yourself, whether, I won't get into that.
Let's not get into a debate,
Yeah.
Mr. Motz.
Thank you.
Please, just to make sure you identify the articles and
This
the
is a
authors.
national,
Point of order.
Mr. Shipley.
Sorry, but he was reading a quote. Do you, Chair, expect him to change the quote? I'm just asking.
Point of order.
Mr.
I'm
Shipley,
asking the chair.
hold on, guys. I just said to Mr. Shipley, I just said to Mr. Motz that if he just read the article and identify the paper that it's coming from and the author. That's
We're
it.
good with that, okay. So he doesn't have to change it, to
Thank
change
you.
the titles. Thank you.
Yes, Mr. Julian.
Thank you, Mr. Chair. We have spent thousands of dollars to get these witnesses here. This is an important bill on cybersecurity. I'm wondering through you if you could ask Mr. Motz to pause the debate, and we can come back to it at the next meeting, but allow the witnesses to provide that testimony. I don't understand why we would take thousands of dollars of taxpayers' money to invite witnesses to testify and not hear them on an important cybersecurity bill.
Thank you, Mr. Julian. Mr. Motz, you heard the question from Mr. Julian. Could you?
yes. I know he's an NDP colleague, but I actually like Peter, and I would, if we could adjourn this debate, I would certainly, on this motion, and for the time that we have remaining, go to C-26. I'm fine with that to honor his request.
He moved a motion to adjourn.
No,
So let's call
no,
it.
he did
Yes,
not.
you just
I
did.
said to suspend this conversation.
You said
on-
adjourn.
I did not move a motion. I'm agreeing with him to say, let's get the C-26 for the remainder of our meeting today, and I'll pick this up at next meeting. Thank you very much.
Agreement of the committee? Yes. Agreed? So, suspend. Yep.